It's an extreme haunted house so intense, some have compared it to a torture chamber. To even step foot inside, you have to get medical clearance. And now, the mastermind behind the terrifying attraction is accused of attempted murder and rape.
Hey everybody, it's Russ coming at you one more time right here from McKamey Manor.
His interest in the macabre, does that make it more likely that he tried to strangle somebody?
The haunted house known as McKamey Manor is no stranger to controversy, but its owner has always pushed back.
This guy has his bases covered with respect to his haunted house / torture chamber.
And the name recognition could make things complicated if it comes time for a trial.
You're talking about something that people know about, both because it's been a source of controversy in the community and because it's been on a Netflix production. So you got to get a jury that can look at this defendant and not make a predetermination of guilt.
But is this spooky background relevant to the charges he now faces?
But the idea that he frightened somebody else in this grotesque haunted house, or I know a big controversy about this house is there's no way out. That's not evidence that he strangled somebody. That's evidence that he runs a creepy business.
Let's start with that so-called creepy business. It's called McKamey Manor and opened in Summertown, Tennessee in 2017. It's marketed as a 10-plus hour extreme attraction. According to the website, participants will incur very physically and mentally demanding environments. It's so severe that there's an intense list of requirements you have to complete to participate, including passing a background check, physical and mental clearance by a doctor, proof of medical insurance, and signing off on a 40-page waiver. The man behind the attraction is Russ McKamey, who has made headlines in the recent past for concerns over his business practices. In 2019, a Change.org petition was started to close down McKamey Manor. To date, it's received nearly 200,000 signatures. Then in 2023, a Hulu documentary was released called Monster Inside, America's Most Extreme Haunted House. Several people who had previously been guests were interviewed for the doc, bringing to light some safety concerns. That's when Tennessee's Attorney General Jonathan Skrmetti announced an investigation into McKamey Manor. In March of this year, McKamey fired back with a lawsuit against Tennessee's AG, claiming his First, Fourth, Fifth, and 14th Amendments were all violated. The next month, McKamey filed an $8.4 million lawsuit against Hulu in response to its documentary. All this brings us to Friday, July 19th, when McKamey was arrested.
Well, my initial question is, this is some sort of domestic dispute gone very wrong. And the question is, how wrong is it, right? There are allegations here that are pretty serious about multiple attempted murder, about rape, and you want to really assess and understand what the truth is, and it's hard to tell just looking at the allegations. And then on the other hand is this very provocative background of who this guy is and the business he ran and his other endeavors, which I'm not sure tells you what the truth is about the allegations, but it does pique your curiosity.
That's litigator Rich Schoenstein. To understand the case better, I sat down with him and asked him how McKamey's background factors into his charges. This defendant is a bit of a polarizing character in Tennessee based on his background. He owns this very severe haunted house that some people have compared to a torture chamber. It's pretty intense. So does that background play in at all? Is this something prosecutors can look into?
Well, I'm sure the prosecutors would want to go there. This is a really interesting point if this case ever goes to trial. Is that relevant to the case? Because I can see the defense arguing that's not relevant. What he does to earn a living, the business he runs, that has nothing to do with his propensity to rape somebody or propensity to commit attempted murder. That has nothing to do with it. That evidence is only prejudicial. It makes him look bad, but it doesn't in fact make it more likely than not that he did physical harm to anybody. I mean, maybe it proves he's a little bit warped in the way he sees the world, or certainly that his business crossed the line. But I think the defense would try to keep that out, and I would really be interested to see how that played out at trial.
I just want to thank everyone for always supporting our videos. And one of the reasons we're able to bring you this content is from our sponsors, like CityLips. Since using CityLips, I've seen results in as little as 30 seconds. But it's not just me. Over 2 million women have tried CityLips. You know when your lipstick just dries out your lips? Well, that's no longer a problem for me. CityLips is the ultimate all-in-one solution. So right now you can get 15% off CityLips with the code LAW15 or go to citybeauty.com/LCnews. McKamey was first charged with domestic assault, but 2 charges of attempted murder and rape quickly followed. According to court records, McKamey allegedly attempted to murder his girlfriend on July 17th, 2 days before his arrest. The next day, on July 18th, there was allegedly a domestic assault. And then on July 19th, prosecutors say McKamey attempted to murder the woman again. And this time, he also committed rape. The identity of the victim has not been publicly released.
I mean, that's a very severe charge, obviously. The attempted murder and rape, I mean, are both in the most serious charges you can have in a criminal case.
But because of the quick turn in terms of the alleged incident and the time the report was filed, some useful evidence could have been collected. This alleged rape happened recently. I know that it was reported pretty soon after it happened, so I'm wondering if it may be possible for investigators to get some sort of DNA or a swab, do a rape kit. Is that something that likely happened?
It could have, it depends how soon the victim reported it, exactly how soon, and if she made herself available for physical examination, and if they did that. This is a scenario where the victim and the defendant knew each other, and may have had relations separate and apart from the alleged rape, which makes it even more difficult to assess and prove. But I'm sure if she timely reported it, some work has been done.
Yeah, that was going to be my next question, because some of the reporting I've seen says that they were in a relationship together. So then it gets me thinking, okay, if I'm a defense attorney, I say, well, it was consensual. They were obviously in a relationship. How then would prosecutors prove that it was rape rather than consensual sex?
Right. Well, I think they're going to have to prove that from the mouth of the victim. The victim's going to have to testify that it wasn't consensual, and no means no. It doesn't matter if you're in a consensual relationship. There can still be rape. We see that all the time. That unfortunately happens. So it doesn't matter if you have sex to people all the time. If there's an occasion where one person forces it over the protestations of another, that is still rape. And so they can prove that if they put the victim on the stand and she's believable, but that's probably going to be the key evidence.
Prosecutors allege that McKamey attempted to murder his girlfriend by strangling her to the point that she lost consciousness. And in this instance, the attempted murder is the charge. And what happened was just what you said, a domestic dispute. Allegedly, he strangled her and choked her. But where does it take the jump from just domestic violence and assault to attempted murder? How did prosecutors make that leap?
Well, I think it's the strangling. So there's all kinds of domestic abuse. Unfortunately, there's verbal abuse, but let's just talk about physical abuse. You can hit a person, you can throw things at a person, you can do a lot of things that don't have any likelihood of killing someone. But when you put your hands around somebody's throat or otherwise choke them, now you've crossed a line. Now you're doing something that can be reasonably interpreted as an effort to end a life. And maybe the defendant has another explanation for what was going on. Maybe the story is that he did choke, but it was only for a moment. He had no intent to cause permanent harm. There might be a story there, but that is an act that could be construed as attempted murder. So I would understand the charge.
There's also the fact that prosecutors say McKamey attempted murder twice and assaulted or attacked this woman 3 days in a row. Does it make things more difficult for the defendant in this case that there's allegedly multiple instances of attempted murder, that he has a past with violence?
Yes. I think that makes it more difficult. I think repeated attacks are harder to defend against. Now, I'm sure the defense might say, well, why did the victim stick around? But we all know in these domestic violence situations that often the victim does stick around, that is unfortunately the way it works out. And I think we're a little bit past the point where we buy that as a defense. So if he did it multiple times, if he was just violent with her, I think that does create a problem. Um, he might argue it proves I wasn't trying to kill her, right? He might argue, yeah, I went too far. I got a little too physical from time to time, but I was never attempting to kill anybody.
If we're talking about the defense side of things, what sort of defense could he bring? I mean, you just mentioned a couple of things, but is it possible that he has a strong defense in his back pocket?
Well, I don't know if he has a story. So we see in a lot of these situations, the defendant has a story. There was abuse on both sides. There was fighting on both sides. It wasn't rape. We were play acting. I mean, there's any number of different permutations that could come out of the defendant as to why this isn't what the prosecution says it is. Also, you still got to get proof beyond a reasonable doubt. You still have to convince 12 jurors that he's guilty. So they may attack the sufficiency of the proof. They may say, listen, they were in a relationship. Stuff happens, arguments happen. Sometimes those arguments get a little bit physical. That doesn't amount to rape. That doesn't amount to attempted murder. They may attack it like that. But we're always interested if the defendant actually has a story, has his own narrative as to what was going on. And I don't think we know that yet.
We haven't heard McKamey's side of things yet, but we do know a decent amount about his background. Well, I think what's interesting about this is that it's a haunted house, but it's not like a traditional haunted house. It's not just like pop out people dressed up like ghosts or whatever, but there's some pretty severe requirements, like people have to complete a physical and mental clearance test from a doctor. They have to have proof of medical insurance. They have to pass a background check. So this isn't your run of the mill haunted house out of a garage. It's pretty intense stuff. So do you think that that could have a leg up for the prosecution to potentially include this?
Also, they have to complete a pretty detailed waiver of any liability, right? So this guy has his bases covered with respect to his haunted house slash torture chamber. He's going to make sure that he only gets people in there that can tolerate it and that they waive their rights. I don't know how that actually is relevant to the charges of attempted murder and rape. I don't think, as I struggle to see how the prosecution could get that in as evidence.
Schoenstein says McKamey may be in the clear when it comes to liability from customers, but could the haunted house play a role in his own court case? So in researching this case, I was looking up videos about this haunted house and kind of going through it, and I looked through some of the videos and they are pretty, I mean, it's not graphic because it's fake blood and fake torture, but it appears to be pretty graphic. Some of these things, again, are pretty intense or pretty extreme. So I'm wondering if they could potentially say he has a fascination with murder or torture, or is this completely unrelated?
Well, I hear you on a fascination for murder and charge, and I read some of that stuff too, and it does look pretty extreme. I'm not a haunted house person to begin with, but I wouldn't go within a mile of that place. I can assure you that is not up my alley. Uh, but I don't, again, his interest in the macabre, does that make it more likely that he tried to strangle somebody? I don't know. I don't think that's a fair connection. A lot of people watch really violent movies. I know, there are some terribly violent horror movies. And do you get to put in evidence that a person sits down and watches the whole Saw movie series in sequence as part of the evidence that they committed some violent act? I don't think so. I don't think it works that way. I don't think what you view as entertainment or what you put on as entertainment is proof of a propensity to commit violence. And I think most judges would probably see it the same way.
Then there's the question of McKamey's past lawsuits and the investigation into McKamey Manor. So the reason a lot of people know this defendant's name, Russ McKamey, is because there was a Hulu documentary about the severity of this haunted house. And his name kind of made headlines, at least locally in Tennessee, because the Attorney General said he was going to investigate, see whether people were actually being tortured or whether this was a bit too severe. So could these past issues potentially come into play, or again, is it completely unrelated?
I don't think it comes into play as evidence, but I'll tell you where I think it gets interesting. You got to pick a jury. And I don't know how big this town is, but you're talking about something that people know about, both because it's been a source of controversy in the community and because it's been on a Netflix production. So you got to get a jury that can look at this defendant and not make a predetermination of guilt. And so his defense is going to work real hard to make sure the jurors haven't already made a determination about him going into trial.
In this documentary about the background of this extreme haunted house, some people who had formerly participated or worked kind of gave a scathing review and pointed out some pretty glaring issues with it. So is it possible that these people could be called to testify about his character, or is that way off?
It's pretty far afield. You generally don't get character evidence of a defendant. You sometimes can get evidence of prior acts that are similar to the act that is alleged. So if he had strangled somebody else or raped somebody else, there might be an argument. But the idea that he frightened somebody else in this grotesque haunted house, or I know a big controversy about this house is there's no way out once you get in, right? Which, by the way, I'm not going in the front door if I hear that. But that's not evidence that he strangled somebody. That's evidence that he runs a creepy business. He's marketing it to thrill takers who want to take on that challenge and go through with it. And that's fine. If he has customers for that business, that's fine. But I don't think that is evidence of his character that would be relevant to the charges we're talking about.
In terms of the case moving forward, Schoenstein says there's still a lot of unanswered questions on both sides of the aisle. What do you think on the prosecution side of things? Do they have a strong case, or would they potentially try to strike a deal?
I think more often than not, the prosecutors try to strike a deal. More often than not, they're looking to get a plea that is acceptable from the prosecutor's point of view and that the defense can live with. So I'm sure there will be some discussion of what kind of plea could be here. I think how strong this case is comes down to how strong the victim's testimony would be. That's going to be the most compelling thing. You know, there's a good chance the defendant wouldn't even testify in this kind of case. He might or might not. That depends on a lot of factors. But the key is going to be the victim's story, because I don't think there's any other significant evidence about what happened. There may be some physical examination evidence about the effects on her, but she's going to have to talk about it.
McKamey's bond was set at $60,000. He's set to appear in court next on August 6th. Reporting for Law&Crime, I'm Gillespie.